Misrepresentation. Hello yet again. This is Forrest Owens. I'm an aviation lawyer, a private pilot, and an FAA licensed airframe and power plant mechanic. Finally, let's discuss the third M, misrepresentation. If maintenance is where the money begins to move, and management is where regulatory exposure begins to form, misrepresentation is where trust breaks down and litigation becomes highly personal. In aircraft transactions, misrepresentation rarely appears as an obvious lie in a single sentence. More often, it appears as selective disclosure, an incomplete maintenance history, an overstated pedigree, a concealed broker conflict, an inflated acquisition price, a soft-pedaled damage history, or a document package that is technically provided but strategically incomplete. This is one reason aircraft disputes can become so expensive so quickly. These are not low-value assets, and the transaction documents often include forum selection clauses, limitation of remedies language, disclaimers, inspection rights, broker provisions, and integration clauses. Once a dispute arises, the fight is not only about what was said, it is also about where the case must be heard, what reliance was reasonable, what was actually disclosed, and which contractual protections survive the allegations. A real-world example to consider is Caron versus Elliott Aviation, decided by the Iowa Supreme Court in 2020. The plaintiffs alleged an inflated purchase price scheme involving a general aviation jet and claimed the true acquisition price had been misrepresented. But the court enforced the forum selection clause because the alleged fraud was not directed specifically at that clause. This is unique in that, or to consider that in a critical lesson for aircraft owners, every serious fraud allegation may not let you escape the procedural rules in your contract. The litigation battleground can be fixed before the dispute is even discovered. Another example is JDI Holdings versus Jet Management, a dispute arising from the purchase of an aircraft in which the buyer alleged that the seller, an affiliate or affiliated maintenance facility, and the buyer's own broker minimized or concealed significant defects, and that the broker had entered into a conflicting arrangement with the seller. The defendants ultimately prevailed after trial, but the case remains instructive because it shows where misrepresentation claims in private aviation often live, not in one false statement, but in a combination of maintenance conditions, broker loyalty, inspection process, and disclosure practice. An older but still useful case is BL Jet Sales versus Alton Packaging, where the court discussed allegations that maintenance and repair information should have been entered into the aircraft logbooks so subsequent purchasers could be fully advised of prior history, maintenance, and repair record. The point is broader than the case alone. In aircraft transactions, records are not merely historical artifacts, they are part of the representation environment. This is why owners should think about misrepresentation in 3 layers. First, assess facts: total time, cycles, engine status, damage history, program status, STC, airworthiness compliance, logbook completeness, and title or lien status. Second, deal facts. Who represents whom? How are commissions being paid? Is the broker truly exclusive? Is there dual agency? Consider whether the seller has superior knowledge and whether any side's understandings exist outside the purchase agreement. Third, procedural facts. When disputes must be brought, whether there is an as-is clause, whether inspection rights were meaningful, whether disclaimers are broad, and whether fraud claims are carved out effectively or effectively boxed in. Here's a point that just sticks. In aircraft transactions, the documents do not merely record the deal. They often determine who wins the dispute about the deal. So, the best protection is not cynicism. It is disciplined diligence. Verify the records independently. Confirm the broker's role in writing. Reconcile oral statements to the purchase agreement. Tie representations to objective documents. And if something material matters, do not leave it in an email or a conversation. Put it in the contract. In closing, you should consider this. Misrepresentation claims in aviation are usually born long before the lawsuit is filed. They are born when a party assumes that access to information is the same thing as disclosure, or that sophistication is the same thing as protection. Thank you for your time and interest in this topic. This information is provided for informational purposes only, and it should not be construed as legal advice. If you have any questions, and they are welcome, please direct them to admin@aviationlegalcounsel.com. We look forward to helping you navigate these issues with precision.